about the delay, and it's wonderful to be here with everyone today. So building on what Professor Bilchitzer said and Judge Colloquium has said in the first session, I want to talk about the value of a decolonial lens for animal law. And I'm doing that because, see if it moves along. It's not moving. Oh, goodness me. I'm doing that because colonization has taught us, as well as apartheid, have taught us that separation and hierarchies are good. So they've put us in this uncomfortable prevailing position, comfortable for some, very uncomfortable for others, of creating socially constructed hierarchies. And we see that in all kinds of settings in our current reality today. We see it when fortress conservation occurs following displacement of people and disconnecting them from the animals to whom they were deeply connected prior to colonization. And we see it in racially constructed hierarchies. And I want to present that to you as those problems as being connected. These problems of separation and hierarchy as being part of an ongoing colonial project, deeply entrenched during apartheid, that today influences the nature of our relationships with the more than human world. Let's see if. And so from this point of departure, I want to remind us that a decolonial lens helps us see things differently. It helps us to reconfigure or restore our relationships with the more than human world, including animals, recognizing crucially that those relationships have been torn apart very purposefully, very systematically through the projects of colonialism and differently. A decolonial lens helps us to think about indigenous people on our continent before colonization. And it helps us to think about the respect ethic and the nature of the relationship between humans and the more than human world before colonization. So it reminds us that humans and nature are not separate. That idea embedded through the legal construct of property ownership, including over animals and over land, a colonial legal construct, through the idea of the nation state, again, a made-up construct. It helps us to appreciate that contrary to those ideas, humans and the more than human world exist in a single, complex, dynamic system. And that system, I and many others refer to as a socio-ecological system. So there isn't a social system separate from an ecological system of which animals are a part. There is one system where humans and animals and the rest of the more than human world are fundamentally coupled, and they depend on each other, us much more so than the rest of the Earth system. And what this approach of decolonizing the discourse around animal law helps us appreciate as well is that we've, through colonization and apartheid, created arbitrary hierarchies that promote domination and oppression of people, as Judge Colloquium said, who are different, or beings who are different. The more different someone is from us, or another being is from us, the more we are able to diminish them and dominate them. But these are irrational and arbitrary ways of being. They've been essentialized in our colonial societies, but they are not essential. We can depart from them and we can return to indigenous knowledges that see our relationships with nature completely differently. So we can return to approaches that resist these artificial, socially constructed hierarchies that are very deliberately designed to oppress and marginalize. Now, if that makes you uncomfortable, that's perfectly natural. We are all existing in this uncomfortable society of domination and oppression, of othering. And so if you do feel discomfort, that is okay. That is perfectly normal. The idea is that we move within that discomfort, because when we're uncomfortable, that's when we can do magical things. When we're comfortable, we don't change. We don't advance a new way of thinking and being. When we're uncomfortable, that's where the magic can happen. And so for too long, our laws, including the laws regulating animals, have overlooked this socio-ecological systems reality that we exist in. They have acted as if artificially humans are separate from and dominant over nature. But that is a lie. And this image is one example of how we've acted in that manner. So we've sought to contain and clean and bottle something so fundamental as water. In the process, we've polluted and destroyed it. And we've polluted and destroyed the animal life that exists within that water. We've distorted our relationship with this most fundamental thing on which we all depend, that makes our planet unique. And what is the consequence? Let's see if I can make it work. This is the consequence. This socio-ecological crisis of pollution, of climate change tied up within the methane pouring out of this dump, of destruction of the wildlife that is eating from this dump. Why? Because we have seen ourselves as separate from rather than a part of the broader Earth system. And what is the onward consequence? Well, there are very direct and immediate consequences for the most vulnerable beings in society, including animals, who have no part in creating this crisis. And yet they are the ones suffering to the point where they will become extinct and we will become extinct. And of course, we're seeing that now more and more. The science is telling us, and this is just one example of socio-ecological crisis, the result of ignoring socio-ecological systems reality, that we are beginning to find large quantities of microplastics in people's brains. And so the circle is being completed, where we thought we could dominate something we simply cannot dominate. We've existed in this artificial reality of socially constructed hierarchies, including over the more than human world. And in the process, we have not only destroyed, not to the point of no return yet, the more than human world, but we are destroying ourselves, our very own brains. And so a decolonial lens invites us to think differently. In the words of Camilla Cabello, something has got to give. So what can we do? Where can we go? Thankfully, we've gotten some clues from our Constitutional Court, and this is already being touched on. Of course, there are many ways to understand our Constitution, and Judge Colloquium explained this incredibly well. And when I speak about human rights-based approaches, please take it that I'm speaking about human rights imbued with values, that human rights in our constitutional setting cannot be separated from values. They exist along a continuum where the values must inform the meaning of the rights. That is how our Constitution has been designed. And what we're seeing is the beginnings of courts recognizing our socio-ecological systems reality. And we must welcome this, even if it is complicated, messy, and uncomfortable. We're seeing this when Judge Kampepe, finds that the rationale for protecting animal welfare has shifted to placing intrinsic value on animals as individuals. We're seeing it in the judgment that says showing respect and concern for individual animals reinforces broader environmental protection efforts. And we're seeing it in a movement around transformative environmental constitutionalism, which tells us that the social justice imperative of the Constitution has to be the starting point for the implementation of the environmental rights. But there can be no social justice if there isn't justice for the environment and justice for the beings that make up the broader environment, the more than human world. And so this social justice imperative reminds us that justice isn't just about outcomes. It's about what happens, who's involved in decision-making, whose voices are heard, including the voices of animals. Do they speak human? No, but do they speak? Of course. And what context is being taken into account? Who's being recognized as valued in the society? And again, that comes back to values and the need to show recognitional justice, not only to human life, but to the more than human world to whom we're connected. Because if we don't, if we ignore that socio-ecological reality, we see what happens. And so again, just reminding us that we're going to a more indigenous approach to understanding the world, that we're challenged to shift our paradigm from one of dominance and exploitation to one of stewardship and reciprocity. My arguments around transformative environmental constitutionalism are that that is what our environmental right demands of us. It is not to instrumentalize the environment, but to recognize the environment's intrinsic value, because without it, none of our human rights have any meaning. We do not have human rights if we don't have a functioning environment within which to enjoy them, whether it's the right to vote, the right to education, or any other right. If the environment isn't functioning, we cannot enjoy or realize those rights for anybody. And so the idea is premised on several different commentators, including Nelson Mandela, Maya Angelou, and Toni Morrison, people that tell us none of us is free until we are all free. But who is the all? I think none of these commentators would disagree that the all must be all beings on earth, that we cannot adopt an exclusionary approach to justice, that justice for people and justice for the more than human world are intertwined. And so we need to, again, sit in this place of discomfort and recognize that if we love freedom, the value of our Constitution, we don't love it for everyone, then what we really love is privilege. And so to abandon these hierarchies over the more than human world is a crucial project of the animal protection movement that we're part of today. Let me see if I can move forward. Sorry. And so what I would like to sort of close on is the idea that we can build on and connect with environmental law where it's useful to try to restore our fractured relationships with the more than human world arising from colonization and arising from apartheid. So this is possible legally because animals fall within the definition of environment. Animal flourishing is bound up with human flourishing and environmental flourishing, and environmental principles in our law have already been usefully deployed to advance this agenda, principles like precaution and prevention. Forward. And so what I'd like to propose is a framework, as is supported, a framework environmental law that has animal-specific principles, principles that recognize animal flourishing, and that has stronger enforcement and compliant mechanisms that adopt a socio-ecological systems perspective. So where to? A decolonial lens helps us resist othering. And I think that's the main takeaway I would like everyone to have from this, that an animal law moving forward must resist othering, must resist artificial hierarchies. It must recognize that our humanness is bound up in the flourishing of all life on Earth. In other words, adopt a socio-ecological systems perspective. And it must embrace complexity and nuanced rather than blunt problem solving. This can be done using human rights along with relevant values. Will it be easy? Absolutely not. But will it be worth it? Definitely. Thanks.
Many thanks, Melanie, for that discussion and introducing the ideas of a decolonial approach and non-hierarchical and socio-ecological crisis. And no doubt we'll discuss many of those things more. Without further ado, I'm going to move on to Dr. Felix Dube. He's a senior lecturer in the Department of Public Law at the University of Pretoria. He previously was at the University of Northwest. He has his publications address, amongst other things, as we will hear, I think, Ubuntu and rights-based approaches to sustainable development and environmental governance. He teaches environmental law, and he's also a member of the South African Human Rights Commission Section 11 Committee of Experts on Climate Justice. Felix, it's great to have you here. Welcome, and the floor is yours.
Thanks so much. I might need technical support moving my slide. If
forward, it should work. It's just you.
So I'm going to move forward.
Sorry. This you.
Okay. Okay. Right. Thank you so much, Melanie, and for the presentation as well. Good morning, colleagues and friends in the room, and those who are online. I would like to start by thanking the organizers of this colloquium, and particularly Amy for facilitating my invitation and also keeping me updated on the program. Thanks so much, Amy. Colleagues, over the next minutes, I would like to trace a simple arc, one that focuses on three elements. The first one being exactly where do animals live in the South African Constitution, and why does Ubuntu give constitutional clauses that are, So let me start afresh, right? Sorry. So over the next few minutes, I want to speak about a three-component arc. One that first speaks to where do animals sit within the South African Constitution, and why Ubuntu gives constitutional clauses deeper moral traction, and how the pending animal welfare bill can operationalize that insight. I hope I get it right from this. So I believe that when we follow this arc, we're then going to be able to move from a reactive legal regime that is focused on cruelty laws to one that is based on a positive and relational duty of care. I must note, however, that most of the research has already been done in this field by the Animal Law Research Project, and thanks so much for that. And I think if I were to say I'm speaking from a position of an expert, I will be misleading the room. So in looking at the parameters of infusing Ubuntu in animal welfare legislation, I wish to note three things. The first one being that anchoring animal welfare legislation firmly within the transformative project of the Constitution is actually not a luxury add-on to how we regulate things, but is also a constitutional housekeeping. Secondly, we need to surface Ubuntu as the normative bedrock on which that housekeeping will rest. This is because often Ubuntu is invoked as a cultural flourish, something that people say to feel good about themselves and their actions. But as you'll see, I will argue that Ubuntu is actually a binding constitutional value and constitutional principle that carries enforceable duties, as it's been recognized as a foundational constitutional principle by the Constitutional Court, particularly in the Petika case. And thirdly, We need to weave the best possible available science on sentience and one welfare into the legal conversation, so that when the new bill is passed, we're positioned to lead an evidence-based discourse as we contribute as academics and as policymakers. If we can agree on that foundation, then the rest of the issues, which are penalties, enforcement mechanisms, and licensing, will just be pure engineering. Everything is just going to fall into place. But why are we so concerned about transformation at this stage? Why suddenly we want to speak about transformation? We would observe that generally animal legislation in South Africa mostly predates the constitution, except for their amendments, yes, that came after 1996, but the bulk of the legislation is pre-democratic South Africa. So this legislation mirrors an era that treated animals primarily as property and as welfare and also as charity. I think this is problematic for two reasons. The first one, it gives rise to questions of constitutionality. We know that anything that was written before the constitutional era needs to be examined and reassessed, especially in instances where there are allegations of cruelty about that particular issue. This is a basic point of departure where arbitrariness is involved, where there is exploitation, and where there are challenges to well-being. And I think animal welfare legislation will fit in there. The second reason why it should concern us is that the legislative mindset that prevailed in the pre-democratic era when these laws were made did not take into account indigenous values and principles. So in my view, this is problematic. And I want to give you a quotation from Justice Mohammed in Makwanyane case. And as I write on constitutional law, I found myself going back and back to the early cases, especially Makwanyane. I think that is where one finds the bulk of the foundation of the South African Constitution. So Justice Mohammed has the following to say, open course, I am of the view that our own ideal indigenous value systems are a premise from which we need to proceed and are not wholly unrelated to our goal of a society based on freedom and equality. You later go on and say, it is only through reference to undisputed indigenous values and principles like Ubuntu that we can create an all-inclusive society. I'm moving, I forgot that I need to move with, with everybody, yes. All right, so I think I will now be on this one. Right, so although the South African Cabinet has tasked the Department of Agriculture, Land Reform and Rural Development with drafting a consolidated animal welfare bill, the courts have started leading the way. In various cases, the courts have linked animal sentience to human dignity. And this is signaling to us that cruelty to animals can violate constitutional rights. And finally, we live in the Anthropocene epoch, a time when the doctrine of sustainable development often legitimizes rather than restrains ecological harm. Animals are particularly at risk as the bulk of our environmental law views them as a resource, just like gold and coal, albeit with some specific variations and protections just because they are living and gold and coal are not living. Therefore, we need a new paradigm of humility and care when it comes to animals. And I think that Ubuntu provides precisely that relational ethic when it comes to animals. Yes, I just want to know something here. But let's not forget that there are certain constitutional hooks that are already in place that we can actually look into if we're speaking on this issue. And I want to proceed and still quote from the Makwanyane judgment again. And that is to contextualize exactly where the South African Constitution fits here before I even speak about Section 34, Section 10 and 12 and 39. And this is what the court had to say. Open quotes. All constitutions seek to articulate with the differing degrees of intensity and detail the shared aspirations of a nation, the values which bind its people and which discipline its government and its national institutions. They articulate the basic premises upon which judicial, legislative, and executive power is to be exercised, the constitutional limits and conditions for the exercise of that power, and the national ethos which defines and regulates that exercise. And importantly, the moral and ethical direction which that nation has identified for its future. And in some countries, constitutions only formalize in a legal instrument a historical consensus of values and aspirations that evolved incrementally from a stable and unbroken past to accommodate the needs of the future. And the court further goes and say that the South African constitution is different. It retains from the past only that which is defensible and represents a decisive break from and a ringing rejection of that part of the past which is disgraceful. It vigorously identifies and commits us to a democratic, universalistic, caring, and aspirationally egalitarian ethos, close quotation marks. So this is where I think the Constitution comes into being. Our Section 24, the celebrated constitutional environmental right, guarantees everyone an environment that is not harmful to their health or their well-being. But the word everyone is in itself capacious, and it has been evolving over time. When I started writing in my early years as an academic, I considered the idea of who is being referred to in the International Bill of Rights, that is the UDHR, the ICCPR, and the International Covenant on Civil and Political Rights. Who is referred to when those instruments say everyone? I concluded that they couldn't have thought that they couldn't have intended to include people in the global south, particularly in colonized territories and many indigenous peoples. So that's why those instruments, 1948, 1960, they will say everyone, but in fact, those rights that they guaranteed to everyone were not applicable to people in the global south. So when we look then at everyone in the Constitution, I think that meaning has evolved. It has now evolved from certain categories of individuals to actually every living individuals. But a new interpretation says that we should look at everyone, the definition of everyone in Section 24 of the Constitution, beyond human beings. That is, we need to look at safeguards of the conditions of life for other sentient beings, which are non-humans, and these are animals. We can attribute the failure to specifically include animals in our Constitution, perhaps to the anthropocentric approach of our environmental law. Oh, I have 5 minutes to go. All right, thank you, bro. So, and then we go to Section 10 and 12, which speaks about dignity, security, and freedom from violence, which come into play when we speak about violence against animals, because it corrodes human dignity. And then there is Section 39 of the Constitution, which speaks about a transformative interpretation of the Constitution. Any court, forum, or tribunal must promote the values that underlie an open, democratic society that is based on human dignity, equality, and freedom. Right. And I want to go back to Makwanyane again, where the court says that the adoption of the Constitution created a perfect opportunity to infuse these historically disregarded values into the mainstream South African jurisprudence due to the need to develop an all-inclusive jurisprudence. And I think this is where Ubuntu will come in. And obviously, the drafters of the Constitution did not have the time, the foresight, and the space in the Constitution to protect everything. Then they left it to us to develop that constitutional project and also to posterity. We have to always change the law and develop it in line with the boni mores and the values that underlie our society, so that we don't have the dead ruling over the living. But then there is the danger of judicial interpretation of what I term constitutional smuggling, in terms of which courts will import through the back door certain values into the Constitution, even though they were not really thought to be there or that are included by the original constitutional drafters. But that's another argument for the day. But in the interest of time, I just want to move and ask the question, are the courts receptive to the lens of infusing Ubuntu into the interpretation of law in general, environmental law in general as well, and animal law in particular? Are they receptive to that ideal? And I think they are. There are two cases that come into mind, but the first one is for the National Society for the Prevention of Cruelty to Animals and the Minister of Justice, where the court said that cruelty to animals ruptures the moral fabric that binds humans to the wider community of life. What we see in this case is the importance of constitutional values in protecting animals, including the intrinsic value of animals as individuals in their own right, and the connection between animal welfare and biodiversity conservation. The court had the following to say: constitutional values detect a more caring attitude towards fellow humans, animals, and the environment. This obligation is especially pertinent because of our history. Therefore, the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals as individuals. What are we seeing here? We see that Ubuntu is being paired with precaution and intergenerational equity. These are classic environmental law principles, creating a jurisprudential platform upon which a modern welfare regime can comfortably sit. I think that the message is very clear for the legislature. The judiciary is laying the tracks, and Parliament must drive that train. This is because the constitutional text and values of Ubuntu, as interpreted by the courts, will gain real-world value only when they have been enforced in legislation. There's much to say about this topic. I had some recommendations that I think can be done to infuse Ubuntu and related values in the welfare legislation bill, but I think we've got enough for today. Thank you so much.
Many thanks, Felix. I think we would be very interested to also see what concrete recommendations you have to infuse Ubuntu into the bill, because I think it is very critical that, as we say, again, the South African law doesn't have to look exactly like other laws. It must represent us. And thank you for putting on board the whole question of Ubuntu and what that will mean in relation to the wider non-human world. Now, I know we're supposed to also have a presentation online. Is that happening or at the end? Okay, great. So our next speaker is Sharon Spicer, who's a sociologist based at the University of the Western Cape. She's currently a postgrad coordinator, and she launched a new interdisciplinary postgrad at Human Animal Studies module in 2020 called Animal Society and the Environment. Her latest research focused on relationships, interactions, and entanglements between humans and other species. And she also runs a Tough Cat, a UWC-based animal welfare project, and is, in fact, involved in the sterilization of cats and caring for animals at her cat sanctuary. So without further ado, Sharon, over to you.
Hello, everybody. Thank you very much for this opportunity. Yes, so I'm a sociologist from UWC. So my talk is going to not focus so much on the sort of legal aspect, but the sort of social aspect, which needs to obviously inform the legal aspect. Yes. Thank you. Yeah, I've got to, forgive me. Do not judge me. I have an inordinate amount of slides. I'm terrible at slides. I hardly ever use them, but I thought I'd better just have some in case. So as a sociologist who also runs an animal welfare organization, I kind of sort of straddle two worlds. I look at animals academically, but I also work with them on the ground, which I think gives quite a unique perspective. I also have a personal agenda when it comes to animal protection in South Africa, because I've got very specific views that I'm hoping I'll put through to you today. And these specific views relate to linking to the concepts of social justice and intersectionality and inclusivity and all these kind of buzzwords that are popular today. But I'm putting forward an argument that animals, particularly companion animals, which is my main interest, maybe need to be considered as a social welfare issue more than an animal welfare issue. I will speak a little bit about Ubuntu and decoloniality, but I think that has already been covered by previous speakers. And the questions that I'm hoping to answer in this brief presentation is trying to look at how lived realities and Ubuntu relates to animals, and also how this approach, which is essentially rooted in African ethics and societal values, could have an impact on animal welfare legislation, but also on animal welfare practice. Because if there are transformations within law, that's going to obviously impact on policy and practicalities and work on the ground, which, you know, I think is much overdue. So I agree with Justice Colloquium that we need to develop a uniquely South African response, but this response needs to be quite multifaceted. And I think one of the ways of doing this is reframing animal welfare and protection as a social welfare issue. To change the dominant narrative concerning animals to this whole idea of caring for the vulnerable. And promoting and bringing to light the violence link, the President has said that gender-based violence is the biggest issue facing the country at the moment. And I think, you know, we all know about the research that's been done linking human violence to animal violence, but I think that needs to be sort of put out into the public domain a bit more. So this uniquely South African approach needs to draw on Ubuntu and decoloniality, which I'll get to later, but I think it can be accomplished by direct action through social institutions and agencies. In education, for example, we know about humane education, but also changing the research agenda at universities. I think it was also Justice Colloquium that spoke about how science is changing and social science is changing to consider animals in a different light, but it's not a uniform process. If you look at social science, for example, my discipline, sociology, actually lags behind anthropology or philosophy or psychology in terms of the amount of research that's been done on human-animal relations. And part of that is a kind of resistance. Many sociologists would argue that by considering animals and by bringing them into the fold, we bring something anti-human. And there's this kind of resistance that needs to be overcome. And one way also of doing this is changing the research agenda to bring animals more into the research agenda, and in subjects like sociology and social work, who I think, because I want animal welfare to be reframed as a human social welfare issue. So one of my personal ambitions is to have social workers doing internships at animal welfare organizations, because this veterinary social work is a new field that's emerging globally, but completely unheard of in South Africa. So I'm hoping that by the time I leave UWC, veterinary social work will in some way be in, I'm busy talking to the social work department at the moment, but you get the same resistance. Then also through the media, not only through popularizing different ideas about animals, but also exposing the hidden victims of crime. Whenever there's a human crime, there's also an animal victim, and that's never brought to the front. So if the media could sort of link human crimes to animal crimes and say, we went to this house, there was this kind of situation at this house, but there were also animals there. So people see crimes against humans, crimes against animals, they happen in the same context. And then, of course, there's religion. Just like many sociologists believe it's disloyal to humans to put animals first, this idea is still very much permeating certain religious beliefs. Within Christianity, for example. Then, of course, you've got the legislature, you've got NPOs and activists who also need to be bringing about these transformations. Because animal protection history and animal welfare, it's actually got a long and complicated history. And it's actually got nothing to do with the environmental movement or the ecology movement. Animal welfare legislation and animal protectionism did not evolve in the same way that environmentalism or the ecology movement evolved. They evolved completely separately. And in fact, the roots of animal protectionism is intricately linked to child and other social welfare concerns. If you look at the very first animal welfare organizations, obviously not in South Africa, but they developed in parallel to slavery abolition, suffrage, vote for women, anti-vivisection, child protection societies. It's in this context that animal protection and protectionism first emerged. In the United States, for example, the very first child protection case was brought forward by the American SPCA because there were no laws protecting children, there were laws protecting animals. And the SPCA went to go and investigate and found a horse that had been mistreated. But while they were investigating the horse, they saw this abused child, and they then actually took it to court and actually used the animal protection legislation to win the case, which resulted in the development of the Humane Society and the New York Society for the Protection of Children. So even though we don't have this exact shared history in South Africa, it's a global cause and its roots are very much linked to human welfare. And I think if we bring this out and bring this out into public, people will view animal welfare and protectionism in a different way. Because there is this tendency to see it as part of environmentalism and etc., which historically it actually isn't. So the struggle for animal rights sheds light on several crucial processes in our social and political history. It also reflects shifts in societal norms and values. And we've got all this talk about values, but it's also assuming that we all share the same values. And it's also assuming that all values have equal status. There are dominant values and there are subordinate values, and the dominant values are dominant. So, so you talk about the Constitution being underpinned by values, but whose values? So, that is a question that also needs to be considered. Early concerns for animal welfare developed in relation to a growing aversion for violence. The first abattoirs, for example, were developed because the public couldn't bear to see animals being slaughtered publicly. Well, some sectors of the public. There was also the sort of there's also the dodgy sector of the public who actually enjoyed the public slaughtering. And Napoleon, who developed the first abattoirs, he saw the privileged sector of society being upset, their sensitivity being upset by the slaughtering, but then he saw the sort of lower classes, the brutes, the violent brutes in society, loving the bloodletting, and he thought, oh my goodness, you know what I mean? You've got to protect the privileged, you've also got to protect the sort of lower sector of society, and therefore by building the abattoir, you're taking this out of the public domain, and you're protecting people's sensitivities, and you're also not allowing the sort of bloodletting to be enjoyed by those who enjoy it. So by the early 20th century, in the early 19th century, animal welfare became a very feminine pursuit. By the early 20th century, there was a significant shift. And part of this had to do with the world wars. I mean, World War I saw the biggest turn in towards vegetarianism and veganism that the world has ever seen, because people were not enjoying the violence, but also it was portrayed to be patriotic to not eat meat. And this is, of course, where Meatless Mondays come from. So, just one thing that I also want to refer to, also there's also this shared history that we have that we need to be reminded about. So we have the shared history with the human social movements that we need to be reminded of, and also we have our own history here. And we need to be reminded that previous laws like the Land Act and the Group Areas Act, they didn't just hurt people, they hurt animals as well. And so using history possibly as a way to win the hearts and minds of people, because that's exactly what Justice Colloquium was saying. How do you get people to see animals differently? And I think we can look to history. I mean, in Chile, they've got this dog called Negro Matapacos. It means black cop killer. And basically, Negro Matapacos is a riot dog. And when there were all these riots, when the population came out and they were protesting against the police, every time there was a protest, this little black dog would arrive and protect the protesters against the police. And he was eventually killed in riot action, but he became immortalized and popularized. He's like a national hero in Chile now. They've got these murals all over, there's stories about him. Everybody loves this dog. And we in South Africa, we've got our own Negro Matapacoses. The Soweto 1976 riot, it began with the dog. Everything was peaceful. But the minute the police dog, a sector of the crowd got a police dog and they killed the police dog, and the police went mad. And that basically precipitated the riot. Maracana, began with, there was the sangoma with the rabbits and the goats, etc. And everybody wanted to kill these animals, and the sangoma told them not to, and then they did, and then there was just carnage. During the apartheid era, there's a song that the UDF used to sing in Cape Town. And in that song, they sing about protection for the hoinkies and the kachis. You know what I mean? So it's in our history. If you look at the PRC reports, Dirk Coetzee talks in detail about how they used to, before they went to assassinate apartheid activists, they would go and kill their dogs first. Charlotte Mpenge, for example, her bull terrier, it upset her terribly. She was completely freaked out, but her and her husband were assassinated soon after. So often the assassination of the animal was a precursor for what was to come. We've heard animals used very negatively during the Zuma period, for example, and I think we sort of need to sort of move away from that. Yeah, so I think by looking at our history and bringing this history into this public sphere, we could actually win the hearts and minds and maybe change people's ideas about animals. I haven't used the slides, as you see, and I've got 27 of them. just to finish off, have I got it? Yeah. So we spoke about Ubuntu and decoloniality, and I don't have the time, but what I would just like to say is that Ubuntu can be used to help us imagine a decolonial animal future. And if we think about this imagined decolonial animal future, what does it look like on a practical level? And I think writing animals into history is one way of doing this. I think dismantling through legal reform, education, and restructuring existing animal welfare principles is essential. And I know there's going to be lots of opposition to this, but remember, these principles were conceived of during coloniality, during the apartheid era. In fact, they were conceived during the Victorian era. So they are imbued with Victorian values. And then I'd also like to connect with other human social issues, rekindle that historical link, and embrace sexuality and social justice. I think it would make a huge impact if when there were human issues, like recently there's been this case of this child that was abducted, that her mother sold, etc., etc. I think if a few animal activists pitched up at court and just showing we support this case, I think that could change things significantly. And this whole idea of pets forming part of the social welfare system and being part of social services and operating in a similar way to like how the child sort of foster system operates, that is a dream of mine. Obviously, it doesn't apply to all animals, but I also don't think that we can look at all farm animals or wild animals or companion animals in exactly the same way. They're in different spaces, they play different roles, and I can understand that an overall justice umbrella, fine, but I think within that, and companion animals, pets particularly, belong in social welfare. And then Nadia Sanger, who is a social scientist at Stellenbosch University, she wrote a paper on Zuma's saying that it's un-African to own dogs, etc. And she debunks that whole thing. And in her concluding remarks in her paper, which I thought was quite interesting, she said that part of this decolonial project should be rekindling our love and knowledge of indigenous animal breeds, and the Canis africanus, for example, needs to have its day. And instead of everybody going after all these pedigree dogs, if you want to really do something African and you really want to do something decolonial, what are you doing with the boerboel? And then what was the last point that I wanted to make? And then the final point that I wanted to make, because underpinning this whole presentation is the understanding, which I believe, that owning an animal, unfortunately owning is the way it is actually not a privilege. And it shouldn't be, because why should it be that only those that can afford it should have animals? Why should it be? Money has got nothing to do with how your feelings for an animal at the moment. And unfortunately, this is the dominant perspective that many people hold. If you can't afford it, you shouldn't have it. It's like some kind of privilege. And I think that's highly problematic.
Thank you very much. Sorry, lots to say, but I have to try and keep us on track. Thank you very much. And I think raising those interconnections between humans and animals so strongly, which come out, and we'll have more time to discuss it. Last but not least, we have Laurie Marino. This is an online presentation which has actually been recorded. We won't play the whole thing, but she's a neuroscientist who studies animal behavior, neuroanatomy, and intelligence. We need science in here as well, right? And she's an adjunct professor in animal studies at New York University, executive director of the Kimmler Center for Animal Advocacy, and president of the Whale Sanctuary Project. Laurie is internationally known for her work on the evolution of the brain intelligence in dolphins and whales. So, without further ado, Amy's going to play a couple of minutes for us, and then we're going to open for questions. So, please hold your questions and look forward to further engagement.
Hello, everyone. My name is Laurie Marino, and I'm very happy to join you for this world event in animal law. So I'm going to share my screen with you. I hope you all can see that. Today, I want to talk to you about science in animal law. And I'm a neuroscientist. I've been working with animal legal advocates for many years now throughout the world. And I want to share with you some of the things that I've learned working with animal attorneys and advocates. So today, I'll just give you a very brief introduction. And then we'll get into some important definitions and concepts. And then we'll talk briefly about finding science, where to get the science, how to interpret it, and how to translate it into something useful for you. And finally, strong versus weak evidence. And then I will conclude. So let's get started. Scientific evidence is key to making the case for animal protection for many, many reasons. The task of arguing or advocating for the protection of other animals really depends very much upon your ability to utilize the science in the most effective way. And even though attorneys don't get science training, today I hope to convince you that it's really important to work with a scientist to maximize your skills in advocating for other animals. So a basic understanding of what science can and cannot do is critical for animal advocates, including attorneys and policymakers. Let's look at some definitions and concepts highly relevant to the notion of welfare in other animals. The big one is sentience, the capacity to feel or have a subjective experience. So the capacity to actually feel pain, feel joy, or feel fear. All of that is key to suffering. And that is the concept around which animal welfare efforts are built. Very important. But there are a lot of different concepts that are floating around that are related but not the same as sentience. For instance, consciousness. Consciousness is awareness. It's being awake. And obviously, if you're conscious, you're also sentient. And then there's cognition and intelligence. And there's been a lot of attention paid to intelligence as something that's highly relevant to suffering, to welfare, and it is relevant, but it is not the only aspect of animal minds that is relevant. Cognition and intelligence really has to do with how one processes, comprehends, and remembers information, problem solving, things like that. And finally, you're going to touch upon the notion of personality, sometimes called temperament. Personality in other animals, including humans, is a consistent pattern of behavior and thought over time. So these are four sort of big concepts that are key to understanding in animal law. And as I mentioned, sentience is really the key to the notion that another animal can have a negative experience, can suffer, can feel pain, can think about their lives in a negative way. Sentience is fundamentally about being able to feel things, to feel pain and have basic emotions like fear. But it also can mean psychological suffering. So if that other animal has the capacity to think about their life and their circumstances, all abuse and exploitation can lead to long-term psychological suffering. And that's different from physical suffering, although they're related, obviously. And then, of course, for many animals who are members of species that have very complex psychology, complex sociologies, there are a lot of complex psychosocial harms that can occur when an animal is suffering. For instance, in elephants, where suffering in one individual can have a huge impact upon the whole group. Now, it's very interesting because if I was giving this talk 20 years ago, maybe even 10 or 15 years ago, it would have looked very different. But the landscape of what we understand about animal minds is evolving very rapidly. Thinking about other animals has changed over time. So, for instance, it used to be that we only attributed sentience, feelings, suffering to familiar mammals, pets that share our homes, our dogs, cats, so forth. And we were unsure about the capacity for suffering in wild, exotic mammals. But now we know that many wild mammals, just like the dogs and cats in our home, are capable of suffering. We used to discount sentience in vertebrates who were not mammals, for instance, lizards, birds, snakes. But now we have come to recognize that you don't have to be a mammal to suffer. And so it's very important to recognize that. Finally, invertebrates have come to the table. We have now a lot of attention on octopi or octopuses. And because they've shown a lot of cognitively complex behavior. So we're starting to realize that even an animal very, very different from us can suffer in ways that are recognizable. But there are still special challenges that we have to meet when it comes to certain categories of animals. For instance, farmed animals, we tend to ignore and disregard and put out of mind the sentience and the suffering of animals who are eaten, farmed and eaten, because we just don't want to recognize who is on our plate. And that's something that's is a psychological barrier that we have to overcome. There are animals who are considered pests or invasive species, like the iguana in Florida. And having that label means that you can ignore their sentience, ignore their suffering, and do whatever you want to get rid of them. So the label itself just sort of sweeps away any capacities that that animal might have for suffering in our minds. Fish, we still have a problem with fish, although there's a lot of scientific data showing fish feel pain, fish have complex cognition. But again, because fish are different and because we eat them, we fish them and eat them, we have a bias towards not seeing them as thinking, feeling beings. Aquatic invertebrates like crabs and lobsters, the same thing. And finally, insects. We know now that many insects are intelligent beings with personalities, socially complex. But again, because many of them are considered pests or because they're so small and we just don't know how to relate to them, it's been difficult. It's been a special challenge to find ways to protect them. So when you take all this together, the old view of humans and other animals looks like on the left, that there's humans and then there's animals, right? So we're qualitatively different, we're separate, we don't have anything to do with each other. And that view has held sway for thousands of years. We now know that that is wrong. The science-based view is what you see on the right. And yeah, it looks really confusing, really complex, but these are all overlapping circles, and each circle is a species. And humans, our species, is somewhere in there. And the point of this kind of graphic is to say that there's nothing about humans that is completely separate from the rest of the animal kingdom, that we share many, many characteristics with other animals. And we really need to be looking at this as an array of overlapping traits, not separate traits. In fact, over the past few years, we've come to learn that there are many complex capacities once considered uniquely human that are now shared with many other species. Tool use, mirror self-recognition, language capacities, mourning, grief, all of these, what we consider to be high-level psychological characteristics, are shared with many other species. So with that in mind, as an attorney, as a legal advocate, how do you translate science? The most important thing to know about science is it's always changing. The literature, the papers are always being updated. And the beauty of science is that it's self-correcting. But what that means is it is a moving target. So you need to be up to speed on not just older literature, but literally up to the minute on the newest and latest findings in a particular area. You don't want to be blindsided by changing findings. So when you're arguing a case, be aware of what the peer-reviewed experimental literature says and whether there are other studies that support or refute that finding. So if you say, you know, in 2019, so-and-so found that pigs recognize themselves in mirrors. You can use that in your argument. But you need to know that somebody else did another study shortly after that that showed that they didn't recognize themselves in mirrors. So if there's refuting evidence or if it's unclear, don't let your opponent bring it up. You should bring it up. Don't be blindsided by the fact that sometimes findings are not crystal clear. And here's some quick tips. Use peer-reviewed papers in peer-reviewed journals, because they are considered the top tier of quality. There's still problems with the peer-reviewed process, but you should mainly stick to the peer-reviewed papers in terms of what you're reporting. When you read these papers and other kinds of literature, beware of biased language and beware of the biased language used by your opponent in a legal adversarial situation. For instance, referring to other animals as it instead of he or she, or using scientific jargon that objectifies an animal. For instance, temperament rather than personality. For the longest time, you couldn't talk about animal personality, non-human animal personality. They wanted to call it temperament. And this sort of denies the richness of the character of other animals. It objectifies it. So be aware that there's that kind of language out there. And you can also use language to bring people to understand who animals are and not objectify them. And then there are some other scientifically inaccurate terms like lower versus higher animals. I don't know what that means. It's not the way evolution works. Or primitive versus advanced, again. And a lot of people will say things like, well, a fish is more primitive than a mammal. There's nothing about that statement that has any veracity, has any validity. So don't let people get away with it. There are two big issues here when talking about other animals and their psychology: anthropomorphism and anthropodenial. Anthropomorphism is kind of the third rail. Everyone was taught the last thing you want to do as a scientist studying other animals is anthropomorphize, meaning attribute human traits, emotions, or intentions to other animals, kind of Disneyfying animals, making them into cartoons, making them into little humans. But things have changed now because we know so much about how other animals share psychology with us that we realize that, you know, all this time we may have been an anthropodenial, meaning denying shared characteristics of humans and other animals. See, it's only anthropomorphism when the non-human doesn't have that trait. If the non-human shares that trait, then it's not anthropomorphism. It's accurate scientifically. So be aware of this. Anthropomorphism is only a no-no when you're attributing traits to another animal that he or she doesn't have. But if they have those traits and they happen to also be shared with humans, don't be an anthropodenial. It is absolutely scientifically correct. And here's a big take-home message. Go out and get yourself a scientist willing to advise you. The power of attorneys, advocates, policymakers working on behalf of other animals and scientists who can give you all of the foundational information you need to make your case, that's synergistic. It's so powerful. And if you are able to work with a scientist as an advisor, you should do that, because it's really, I've seen how important it is from a scientist point of view. And more scientists are willing to work with animal advocates and animal law efforts. Now I want to turn to a little bit about how you navigate through the scientific literature and how you can differentiate strong versus weak evidence. Because if you're in court of law, you want to use the strongest evidence possible to make your case. And it turns out that the strength of scientific evidence is really based upon how well you can say X causes Y, how you cause and effect is occurring. And for instance, if I say something is correlational, every time it rains, there are more umbrellas out on the street. Well, okay, but that's, that's something that is a correlation. It's not like umbrellas cause rain. Only experimental studies allow you to determine cause and effect. So experimental data trumps or defeats observational data and case studies in all circumstances. And when you're navigating the scientific literature, there are some important questions you should ask yourself to determine the strength of the scientific evidence. For instance, who did the research? Is the research done by a group that has a conflict of interest, for instance, the zoo and aquarium industry, the tobacco industry, et cetera, et cetera? Is the study peer-reviewed? Is it reviewed by your peers and in a peer-reviewed journal? That's critically important. And again, peer review is not perfect, but it's the best we have right now. Are the findings based on systematic, objective data or just stories or anecdotes? Anecdotes can be helpful, but they don't hold as much weight as actual objective, systematic findings. Does the conclusion match the findings? Does this paper, the conclusion of the authors of the paper, actually come out of what they found, or are they going beyond the data? And is the study cherry-picked? So this is a big one, right? You're going to look for studies that bolster, support your case. Well, your opponent is too. And that's why it's really important to know the full landscape of what's out there, because you may be tempted to cherry pick all the papers that make your case. Your opponent is doing the same thing. So in conclusion, animal law and advocacy requires navigation through a complex landscape of different studies and different levels of evidence. It is critical to use the strongest level of evidence appropriate to the situation and avail yourself of the guidance of scientists who can serve not only as witnesses, but as advisors. So let's work together. I really want to thank you for this opportunity. If you have any questions, please don't hesitate to email me at marinolourie@outlook.com, and I'd love to have a conversation with you about any of these issues. Thank you. Thank you, everyone, and enjoy the conference.